Good morning and welcome to the webinar this morning. My name is Nikki Hardwick and I am an HR consultant from HR Talk. I have been dealing with employment equity for probably about 18 years, and today I will be assisting in presenting the webinar today and hoping to help you understand the things that are required from a business perspective, and then also in dealing with some of the changes that are possibly coming in when the president signs off the amendments. So that's really what we're going to be dealing with today. If anybody has any questions, you're more than welcome to share them in the chat group, and I will deal with the questions later. Alternatively, you can email us on info@hrtalk.co.za. This webinar will be posted on our YouTube channel. Alternatively, it will also be posted on all of our social media channels and on our website. So thank you for joining, and we'll get into the webinar right now. All right, so when we look at employment equity and understanding employment equity in the workplace, it's important to understand the Employment Equity Act and how it applies to a business and how it applies to businesses in South Africa. So the Employment Equity Act was developed and was put into place in South Africa in 1999. And so it's been in South Africa for a long time, a number of years. So it's not a new piece of law to employers from 1999. So basically, there's two elements to the Employment Equity Act. The first one, which applies to all employers, is the act was developed to eliminate unfair discrimination in the workplace. So it was to promote equal opportunity and fair treatment in employment through the elimination of unfair discrimination. And that element of the act applies to every single employer in South Africa, regardless of how big or small you are. There is an onus on every single employer within South Africa to ensure that there is no unfair discrimination within the workplace. And what the Act does is it also defines for us how they define unfair discrimination. So, and I'll go into that very shortly, but they have 5 elements within the Employment Equity Act of what is deemed to be unfair discrimination. Then the other side of the Act is the implementation of affirmative action measures. Now, the implementation of affirmative action measures is specific to what we call is designated employers. So we've got the one side, which is the elimination of unfair discrimination, and the other side, which is the implementation of affirmative action measures, which is basically when we look at affirmative action measures, very often when I go into committees, I go into employers, people have an understanding of what affirmative action is and apply that to their business. And when we apply affirmative action, what they do is they go, affirmative action specifically relates to one particular gender, it relates to one particular race group. And so what they do is when they apply affirmative action into their business, is they apply it from a perspective of going, affirmative action only applies, as an example, to African females. That is actually not the case when we look at affirmative action. Affirmative action, when we look at every single workplace, applies to people from designated groups. And in South Africa, a designated group is not just an African female, it's not just African, it applies to African, Indian, colored people, women of, so all women and people of disabilities, all races and all genders. So when we look at affirmative action measures, what we're required to do, from a business perspective, is we have to look at our workplace and we have to look at what is our numbers within our workplace and what is the transformation within our workplace, and identify, do we have too many men? Do we have too many women? Do we have not enough this group, not enough that group, and to try and ensure that we transform within the workplace. And if, as an example, we know we don't have any people with disabilities, and we don't have people with disabilities because we don't have the facilities within our workplace, what we are now required to do is to implement an affirmative action measure to get rid of that barrier to employment equity. So in our workplace, if we don't have people with disabilities and we implement something within our workplace to make it easier for people with disabilities to come and work there, that is our affirmative action measure. We could have a workplace as an example where, for argument's sake, historically our workplace was one in which it was a male-dominated workplace, and so our workplace is predominantly set up to accommodate males in the workplace. And so what we have is we only have male bathrooms, we have male change rooms, and now we want to create a space where we trying to encourage women to come into the workplace. A barrier to employment equity is the fact that we don't have bathrooms or we don't have change rooms for women. So an affirmative action measure to encourage women to come to our workplace would be to create a bathroom, a change room, or something like that to enable women to come into our workplace. So affirmative action measures are not specific across the board to a particular race group or particular gender. It is based on your particular workplace and where you are falling short in terms of redressing disadvantages by people within the designated groups to ensure that your workplace starts to transform. So we need to be careful within employment equity of applying our predefined understanding of what affirmative action is, and rather to look at our particular circumstances, and every workplace will be different, but is to look at our particular work circumstances. What is our representation look like? What are the challenges that we specifically face, so that we can look at our barriers to employment equity and then implement our affirmative action measures accordingly. Okay, so just going back a second. So when we look at the Employment Equity Act, there's really the two elements. The one is the elimination of unfair discrimination, and the other, which only applies to designated employers, which I will go through now, is the implementation of affirmative action measures to redress the disadvantages or to address the barriers to employment equity. Okay. If we then go, and as I said before, the first part of employment equity was the elimination of unfair discrimination. So there's 5 elements when we look at unfair discrimination, and it's very clear within the Act that there are the 5 elements of unfair discrimination, and this applies to every single employer in South Africa, regardless of how big or small you are. The first one, and this is almost the cornerstone of employment equity and has been in the Act right from the beginning, which basically says, and this is just a small part of it because there's a number of different elements to this one, which basically says that no employer or person may unfairly discriminate against any person on the basis of race, gender, sex, pregnancy, marital status, family responsibility. It goes on, it says social and ethnic origin, age, and there's a number of different ones, and then it ends off with going culture, language, birth, or on any other arbitrary ground. And in essence, what this element is saying is, if we go back to our history within South Africa, is people were discriminated against based on a particular category that they were in. So because you were a particular race group or you're a particular gender, there were things you were and weren't allowed to do within the workplace because of that particular element that you had. So this part of the Employment Equity Act says that no person may unfairly discriminate against any employee on the basis of race, gender, sex, etc., all on its own. So you cannot decide that you will not employ someone just on the basis that they are African, white, Indian, colored, whatever the story is. You cannot decide that you're not going to employ someone on the basis alone that they are pregnant, on the basis that they are a female of childbearing age and you really don't want to deal with maternity leave. So you cannot discriminate on that basis alone, unfairly so. With that said, though, is that not every type of discrimination is necessarily unfair. There are elements of fair discrimination in which, provided that we can do a fair justification, we might have elements where we can say, for example, as a security guard that needs to search people, the rules are that in our workplace, we can only have males searching males and females searching females. If I don't have a guard to search females. When I'm employing a guard, I can limit the employment of that guard to females because I need a female to search my female staff, as an example. So there are elements of fair discrimination, but you need to ensure within your workplace that you have no policies or practices that that specifically exclude someone on the basis of these things alone. Remembering that when we look at the definition of an employee, that includes anybody that is even applying for a job. So although the person may not have got the job, they have the grounds and they can go to CCMA and make a claim of unfair discrimination if they are not appointed to a job, and they can make the claim to say, I was not appointed to the job because, as an example, I'm female. And they can make the claim. The grounds to make those claims are obviously different depending on, so the burden of proof is different based on if you're going to make a claim based on race, gender, sex, etc., or if you make the claim on an arbitrary ground. And that's all included within the Act to that now. But a person coming into a position applying for a job can make a claim of unfair discrimination if you discriminate against them based on race, gender, sex, etc. So even so much as saying that there are case laws which say, as a woman, if I can't just discriminate and not give me a job on the basis that I'm pregnant, because that is an automatically unfair discrimination. Okay. So we then have the second form. So that is the first form of unfair discrimination, is that you cannot discriminate against someone on the basis of those things, alone on those things. You can have fair discrimination, but you cannot just decide that you're not going to employ someone on the basis of those. The second thing is that we have the second form of unfair discrimination is that you cannot discriminate against someone or have a difference in terms and conditions of employment between employees of the same employer performing the same or substantially the same work. So basically what that means, and when this originally came out, I believe it was in 2014 or 2019, is what happened was this was basically the equal pay for equal work. Okay, and when this came out, everybody then jumped on the back, must 100% earn exactly the same, regardless of my performance, regardless of how long I've been here. So everybody must earn exactly the same amount of money. That is not what this element is saying. It is basically saying that if you have two employees that are doing the same or similar job, is what you cannot do is you cannot have a difference in any terms and conditions. So it is not specific to a salary. It's any terms and conditions of employment. Is you cannot have a difference in those terms and conditions if those differences are as a result of anything relating to point one. So if I look at my workplace and I can see there are two people that are doing same or similar job. They've been there the same amount of time, but I can see that there is a difference in, their terms and conditions. And I know that historically it was because one was a male and the other one was a female. That is unfair discrimination. And there was ability within the Code of Good Practice to start to fix that. So as an employer, we have a responsibility to look at how people are paid and then to ensure that if there is a difference in any terms and conditions, that it is not as a result of race, gender, sex, pregnancy, family responsibility, etc. We can have a difference in terms and conditions, and the Code of Good Practice does specify that there are scenarios in which a difference in terms and conditions is 100% justified, and that relates to things like skills, experience, and a number of things like that where somebody is allowed to have a difference in terms and conditions. It could be somebody's been demoted. There's a number of different things in which it is justified to have a difference in salary or a difference in terms and conditions. But as the employer, we are required to ensure that people are not earning different amounts in salaries, don't have different terms and conditions, if those differences are related to anything in point one. Then we come to the third form of unfair discrimination, and this is recently changed as well. But basically, what it says is that harassment of an employee is a form of unfair discrimination. It's obviously not permitted. Up until recently, the one form of harassment, and we had a code of good practice, which was sexual harassment. So it was very specifically dealt with in terms of what is sexual harassment and how an employee needed to behave in the workplace, what an employer needed to do if there was a claim of sexual harassment. That code of good practice was amended on the 18th of March, and now basically includes all forms of harassment. So as an employer, in terms of the code of good practice, there's a very specific responsibility that you have as an employer to deal with harassment in the workplace. There's very specific things that you need to do. And if there is harassment in the workplace and you don't deal with it, you can be held liable for the thing that the harasser has done to that employee. So it's very important that as an employer that you deal with harassment correctly, that you train your employee and you follow the code of good practice, and that you make sure that within your workplace people understand how they're supposed to behave, and then what happens if there is an allegation of harassment. What is also key about this form of unfair discrimination is that it is not specific to an employer-employee relationship in terms of those that can be harassed and those that can do the harassing. So in terms of harassment, an employee, if we want to call it that, is defined as pretty much anybody who comes into your workplace to do any form of work. So if you have people coming in to volunteer, you have interns, you have people coming in as a contractor, as a client, all of those people are covered underneath the code of good practice on harassment and must be protected from being harassed within your workplace. And there is a responsibility for you as the employer to ensure, one, that you tell people how they must behave, and two, what happens if harassment happens. So we will be holding a webinar later in the year on this particular code, and we do offer training to both employers as well as employees in terms of harassment and understanding that. So it is the code is very clear in terms of responsibility, and if an employee is harassed, and I want to make this clear at this point, when we talk about employee, we're talking about the genuine employee-employer relationship, but we're also talking about anybody who comes into your workplace that is possibly paid or not paid. So it includes volunteers, it includes clients, suppliers, a number of different things. So pretty much anybody that comes into your workplace to do work is protected against harassment. And so it's very important, based on the code of good practice, that you get this right within your workplace, because if you don't do it right, you can be liable for the harasser's conduct if you fail to do this correctly. Okay, so that is the third form of harassment. And sorry, just to be clear as well, harassment includes all forms of harassment. So it's sexual harassment. They call it social and ethnic origin harassment, which is basically racial harassment, and then all forms of other harassment, which includes bullying, victimization, emotional abuse. There's a number of different things that a person within the workplace can be harassed, and so it's quite a broad thing, and it's important that as an employer that you put this in place. Okay, if you do want any information on harassment, please email me afterwards, or email info@hrtalk.co.za. We do have a policy, we do have a procedure, and we can offer training for your employees as well as management in terms of how to deal with that. Okay, then stepping on to the fourth form of unfair discrimination, which relates to medical testing. And it basically says here that medical testing is prohibited unless legislation permits or requires the testing. So that is where you have a particular job, or you have something that requires that you do an annual medical, or before you can do the job, you are required to be tested, or it is justifiable in light of medical facts, employment conditions, social policy, fair distribution of benefits, or the inherent requirements of the job. So in essence, what this is really saying is that I can't just decide that I'm going to medically test you just so that I can see if there is something wrong with you. I need to be justified in terms of any of these things before I can specifically send you for a medical test, remembering that the purpose of this is to say, why do we want to test people? We want to test people to know if they can or can't do the job. Okay, so if I'm going to take you for a test and I'm going to possibly discriminate, i.e., exclude you from a position or exclude you from a promotion, then that needs to be justified. We can't just do medical testing on people, and why would we? So the medical testing is there so that we can decide whether or not a person can do the job, whether or not they can get particular benefits, whether or not they can work in specific conditions. So the idea behind medical testing is that, in essence, we're going to exclude someone. So when we're going to exclude someone, i.e. discriminate against someone, the purpose of the medical testing is we need to fairly discriminate against someone. So to decide based on the occupational conditions, these are the occupational conditions, and I'm testing that person against this. And therefore, when I discriminate, remembering that discrimination is not necessarily always unfair, when I discriminate against the person, I'm discriminating fairly based on the inherent requirements of the job or the employment conditions. And then the final form of unfair discrimination relates to psychometric testing, remembering that, again, we're going back to why is it a form of unfair discrimination, is that if people are using psychometric testing as a reason to exclude or include people, then the psychometric testing needs to go through a certain test. So that certain test, and I know having, looked at psychometric testing in the past, if it's a valid and reliable psychometric test, it has to go through certain criteria anyway. And that is to make sure that it is scientifically correct, it's fair and valid. And there's a number of different things within the Employment Equity Act that specifies if you're going to use a psychometric test to include or exclude people, it must meet certain requirements. So if you are using psychometric testing within your business to include or exclude people, so you use it as part of your promotions or your recruitment process, you just need to make sure that it is a psychometric test that has been tested properly and that can be applied fairly across all people within your workplace. Okay, so those are the elements of unfair discrimination that as employers, we need to ensure that we are abiding by, to ensure that within our workplace, regardless of whether you're designated or not, you have to comply with these. So any person, whether you are doing your equity meetings, and we'll go through now what is required of a designated employer, but every single employer is required to ensure that this doesn't happen within their workplace. And every single employee, remembering that an employee is not defined by somebody who is necessarily in a true employer-employee relationship. It can extend, when we look at harassment, when we look at recruitment, it even applies to somebody who is applying for a position. And so these are the elements that within our business we need to ensure that we're not doing. Okay. Then if we go through to what is not unfair discrimination. So firstly, it is not unfair discrimination to take affirmative action measures. So what that in essence means is that if I have an employment equity plan and my employment equity plan says that I need to employ, for argument's sake, a person with a disability. So I have 5 people that come for an interview, 5 people who are sitting in front of me. One of those people happen to be someone with a disability, and I choose that person over the other people because they have a disability. The 4 other people, if they make a claim of unfair discrimination because I excluded them because they didn't have a disability, if I have my plan and I can say I took that person because my plan required that I employed someone with a disability, that is not unfair discrimination because it was specified within my plan. If it wasn't specified within my plan, then it's not necessarily an affirmative action measure. So you need to ensure that if you're going to include or exclude people on the basis of race, gender, sexual orientation, et cetera, that you make sure that you have an employment equity plan that specifies what it is that you're trying to achieve. Otherwise, you should try and steer away from including or excluding people on the basis of any of those things. Okay. It is also then not unfair discrimination to distinguish, exclude, or prefer a person on the basis of the inherent requirements of the job. And in essence, why this is there is to say that even with employment equity, when we're trying to meet certain, objectives within our employment equity plan, we're trying to transform. We need to remember that even in that basis is employing people who don't have the particular skill or don't have the inherent requirements of the job, is we don't necessarily just employ on race, gender, whatever to meet a number. We can exclude people, and it is fair discrimination if we exclude people because they don't actually have the inherent requirements of the job. So they're not skilled, they don't have the experience, etc. And that would not be unfair discrimination. Okay. So as I've mentioned before, although every employer must take steps to promote equal opportunity in the workplace, by eliminating the unfair discrimination, there are certain employers that are deemed to be designated. And those employers have certain requirements, which we're going to go through now. So I do need to make it clear at this point that there are some changes that are coming in. So the Employment Equity Act is being amended. It is currently with the President waiting to be signed, and there will be some amendments, which I'll go through, the key amendments later, but one of those amendments is, well, at least it relates to this turnover. So designated employer currently is any employer who employs 50 or more employees, remembering that an employee includes both temporary as well as full-time employees. So I have a number of clients that will say, no, I only have 10 permanent employees. But when you look at the total number of employees that come through their business, is they will have 10 permanent employees, but 30 fixed-term employees. Well, that wouldn't work anyway. So it's 10 permanent employees, and let's, for argument's sake, say 60 fixed-term employees. And so what happens is the number goes over 50, and by virtue of the fact that they've gone over 50, they're designated by virtue of the Act, and therefore are a designated employer and need to comply with the second part of the Act. The other designated employers are anybody who employs fewer than 50 employees, but their total annual turnover exceeds the turnover in terms of Schedule 4. Now, this is the element of the Act that is is currently under review. And when the President signs it off, this will no longer apply. So if you have less than 50 employees, you are no longer designated and you will not need to comply with this second part. There are also other employers who are appointed by collective agreement and municipalities, which I'm not going to go through now. But as it stands at the moment, if you have less than 50 employees, but your turnover equals or exceeds the applicable turnover in Schedule 4, or you have more than 50 employees, then you are designated in terms of the Act. So this is the current annual turnover, but I'm not going to go through it hugely now because this is going to, and we're waiting for the legislation to be passed. We are hoping that it is going to be soon because it affects a number of employees, or at least employers that possibly will no longer be designated. So we're waiting for those changes to come through. All right. So when we then have a look at as a designated employer, so this is anybody that is over the 50 and currently anybody who has the turnover. If you are under 50, but your turnover exceeds it, then get hold of us afterwards so we can assist you in terms of deciding how you want to move forward. But going through as a designated employer, there's a very specific process. So I'm going to go through the process with you as if you have never implemented employment equity. So first and foremost, what needs to happen is as a designated employer, the first thing that you need to do is to assign a senior manager. And the senior manager, part of their job description needs to be, and they need to be assigned in writing. So you as the employer need to appoint a senior manager to be responsible for the implementation of employment equity within the business. So that person now gets designated in writing. So it can't just be somebody who is designated and you've given them a job title. You need to give them a letter which says that you are now responsible for the following things within your business. Depending on the size of the business, you can have more than one senior manager, but you do need to have somebody who is responsible, and that person generally, when you're doing your annual report, will be listed on the employment equity reports. So that is the person who's responsible for the implementation of employment equity. They also need to be a person that has the ability that can actually implement change within the business. So when you're assigning a senior manager, you can't assign someone, or in essence, you shouldn't be assigning someone who actually can't affect any change within the business. So it needs to be someone that is at a level that can consult with you, but can also ensure that other managers and people within the business will listen to what the person has to say. Okay. Once we've assigned our senior manager and that person has been designated the person to implement employment equity within your business, what we are then responsible for doing is doing communication awareness and training of the employees within the business. So what we're required to do, and there's no specified way in which we need to do it, there's no specified format. It also doesn't really say that how often we need to do it, but when audits are done by Department of Labour, the general sort of consensus is that this needs to be ongoing. So we can't do one session of training and then never do it again. Our job as an employer is to consistently make employees aware of the act, so make them aware of things like discrimination. So going back to harassment in the workplace, one of the responsibilities is to ensure that employees understand what is harassment, what is discrimination, is to start unpacking diversity issues within the business, but is constantly trying to get employees aware of things within the workplace and what not necessarily what their rights are, but is understanding how people need to be behaving so that we as a business can slowly start to transform. And some examples of places where this becomes appropriate is you could have historically, again, I'm going to go back to male-dominated fields, where we are now trying to transform is to bring females in. And the challenges that we have in those environments is you might have a workplace that's historically male, and although we want to transform, the employees that we have are hesitant and resistant to that change. And so as the employer, we need to go through a process of trying to get employees to accept those changes. So when we start to transform as a business, we may also need to do work with the employees that we can get to the point that we can transform. And so as the employer, we need to continue to do this communication, awareness, and training. Then we have the document called the EEA-1, which is the employer, or at least the employee declaration. And basically what this is a document that confirms, so if as every employee, we need to ask every employee to complete it. And basically what this form is it says, I'm African, Indian, colored, or white, I'm a foreign national, I'm a South African citizen, and do I have a disability? So we need to request that employees sign it. An employee has the right to refuse to sign it, but the purpose of the form in essence is to ensure that the data that I'm collating is actually correct, that I'm not making an assumption that when I look at a person, that person is African, Indian, colored, or white, or whatever. I'm not making an assumption based on what I see of what the person is. I'm taking the data as the person gives it to me, and I'm using that particular data to complete my forms. That information from a POPI perspective obviously needs to remain confidential. You wouldn't keep those forms in an employee file, because if an audit is done by Department of Labour, they may request to see those forms. So the recommendation is that you have a file in which you keep the EEA-1s. It is obviously separate, but from a POPI perspective, it shouldn't be available for everybody to see. So it must be locked away, but it's a document that you keep so to ensure that the information that you have is actually correct. Okay. Then what we need to do, remembering I'm starting from the beginning, as if you have nothing in place. So some of you may be in a place where you have got the committee, you have kind of done things, or you've started with the committee, but you've missed a whole lot of steps prior to this. So if we've got to the point where you've got a committee, but you haven't appointed the senior manager, you haven't done the EEA-1, etc., then what we need to do is you kind of need to step back a bit and you need to put those things in place. Okay, so assuming we've gone through those steps, is what we then need to do is we need to appoint the Employment Equity Committee. These must be representative of all stakeholders. Ideally, these people should be elected and not selected. So what that really means is, as the employer, sometimes what will happen is I will decide from an employment perspective that from a selective perspective, is I only want to employ people in my committee who are going to say the things that I want them to say. And so what I do is I only select a few of the top managers, and those are the people that I put on my committee, and those are the people that I ensure are going to say whatever it is that I need to say. The Employment Equity Committee ideally should be representative of all stakeholders. So when we look at the organization, you cannot have a committee that is only the people on the shop floor. So it's not it's not a forum. It doesn't replace our union meetings. It isn't a union meeting. It is everybody going through the things. So if we have males and females, if we have African, Indian, colored, whites, if we have foreign nationals, it should include representation across all levels, and it should also include everybody within the workplace that should come to that meeting. Remembering that when we look at our employment equity meeting, is what it is the Employment Equity Committee is actually a consultative forum. It is not a committee that can actually make decisions. So they are not responsible for the implementation of employment equity in the business. Their job is to consult to the employer and to allow the employer to make the decisions. And that is because when we look at the fines, so as an employer, if we fail to comply with the Employment Equity Act, there are fines, which we'll go through just now, but there are fines that we as the employer can be responsible for. So there's up to 1.5 million, depending on what it is that you've done. If the committee themselves are responsible for the implementation of employment equity within the business, then they too are held accountable if things go wrong. So as the committee, our job is to consult to the employer, but ultimately is to allow the employer to make the decisions and to be responsible if it doesn't work out at the end. The other thing as well with the committee is that they're required to meet either quarterly or monthly. And this lines up with the monitoring and evaluating mechanisms, which we report on an annual basis. So you will see within the Employment Equity Report, it does ask is how often do you conduct monitoring and evaluating? It gives you the option to do either quarterly or monthly. So when an audit is done as well, is what will happen is you, the Department of Labor will then say to you, how often are you meeting? They will ask for committee meeting minutes. They will specify, and they will come to you and they will say to you, has your committee been meeting? Can I interview your committee? And they will ask you if your committee has been meeting, and they will do interviews. So it's incredibly important that you have your quarterly meetings or you have your monthly meetings, and that you have agendas and you have minutes that line up to those things. The other thing as well is that you do need to conduct workplace analysis. So what this is, and this happens prior to the employment equity plan. So we now have the committee, and we now need to conduct an analysis. This is done using the EEA 12. And when we do the EEA 12, we conduct an analysis. Basically what this is we look at the workplace. We identify what does our workplace look like. So how many African, Indian, colored, white, at what levels are our employees sitting at? So how many people do we have at top management, senior management? And we conduct an analysis to see what does our demographics look like? And at that point, what we then start to do is to say, what do our demographics look like? And currently, and this is going to change when the new amendments come through, is we look at our demographics in comparison to the economically active population of both our regional as well as our national demographics within the workplace. So the current requirements is we look at our workplace and we say, as an example, we have 50% African people within our workplace. If we look at KZN or Gauteng or wherever it is that we're working, KZN as an example has 86% African in the workforce. National has 80% as an example. My workplace is 50%. So how am I going to get from that place to that place? And so I need to conduct an analysis to say, why do I not have enough males, females, people with disabilities? What are the barriers to me achieving my employment equity, and what are the challenges that I'm having in my employment equity, and why do I not look for example, as the demographics. Why do I not look like that? I then need to conduct that analysis. I then will understand what are my challenges, so what are my barriers to employment equity, and as the committee, we put this document together and then we suggest to the employer what are the suggested affirmative action affirmative action measures that we can possibly put in place. So when we go back, remembering affirmative action measures are not specific to a particular race group or gender. It is based on my particular issues that I have in my workplace and why my demographics are not in line with the demographics of the national or regional demographics. What are the challenges that I'm currently faced with? So going back to, I don't have any people with disabilities. What are the barriers to my employment equity? So why don't I have people with disabilities? And how do I fix that? So if we look at our workplace, we say, well, we don't have people with disabilities because our workplace is not set up to allow people with disabilities. And so as the committee, we might say, for argument's sake, well, if we have a look and we change the workplace to allow for people with disabilities, that will then eliminate the barrier. So we will suggest to the employer, these are the affirmative action measures that we want to put in place. The employer will then take that, will then agree or disagree, remembering that there's budgets in place and whatever, is the employer will then look at what we have specified as the Employment Equity Committee. They will then approve or possibly amend things. They might push things out, but we will put our analysis together, and our analysis will then inform our plan. So we then have our plan, which is done in the EA13 format. So you cannot define your own format. You need to put it in place in a format in terms of the EA13. You can decide it can be anywhere between 1 and 5 years long. And so what you will do within your plan is you will then say, this is where we're starting today. If we look at our numbers, we look at our barriers, and we look at what needs to happen, is we will then put our plan, and the legislation currently says it's anywhere between 1 and 5 years long. So you can put in place a plan, and what will happen is you will set your targets within the plan. You will say, I'm currently on 50% African as an example. I would like to, within the next 5 years, I project that I will get to a point that I will be, for argument's sake, 60%. And you will then specify how are you going to do that. So what are the things that you're going to put in place to try and achieve that? You might put in place an affirmative action measure that you say, in 5 years' time, I would like to get to a point of workplace that is people with disabilities. Part of your plan may be to say, well, what I'm going to do is I'm going to, for argument's sake, say, we're going to change the bathrooms. That's going to take 3 years. We're going to put in a ramp as an example. That will take 4 years. And so your plan will specify what it is that you are going to be doing. And obviously, as the committee, our job as the committee is to take the plan and to monitor and make sure that we're kind of staying on target. If we're not staying on target, the questions need to be asked is why we're not staying on target, and do we need to review and revise? Okay, so part of that thing is the monitoring and evaluating mechanisms. So we need to meet quarterly or monthly as the committee. And what we need to do is we need to start to keep records. So we need to do minutes. We need to discuss what it is that we're doing. We need to have structured. So part of the thing that the employment equity manager needs to do is to ensure that what we say that we were supposed to be doing, have we been doing it? The equity manager should also be part of the committee. They need to be sitting in the committee because they need to know what's happening. So they need to be there. They need to be discussing with the committee. And the committee really needs to be looking at what it is that we're doing on a quarterly basis. And if you're meeting monthly, which doesn't generally happen, but if you're meeting monthly, are we moving in the right direction? And what we then need to be doing is if we're not making progress, we need to understand why. So we may implement an affirmative action measure as an example. So we might, in this case, we want a person with a disability. So we may put in place our affirmative action measure, which is, for argument's sake, we'll build a ramp, we change the bathroom, and now we're ready to start employing people with disabilities. And we find out that we're unable to get those people with disabilities because nobody's applying for a job. So we are struggling to get a person with a disability because that person or those people are not applying for the jobs. There's nobody with a particular skill, so we're unable. So what we will then do is to identify that there's now another barrier, and so what we will start to do is to review and revise. So we started with one barrier, we fixed that barrier, and we now got to the next barrier, and so we start to change, and we try and move to a place that eventually we've eliminated all the barriers to ensure that our workplace can possibly transform. There is a space that, in as much as we eliminate barriers, we may still sit in a position where we've now eliminated all the barriers, but we still can't get those people because there are factors that are outside our control that we can't necessarily fix. So that's what we need to be doing on a quarterly basis. That is what we're required to do constantly within the business. And then finally, and this is where most employers understand and have been working on an annual basis and have been for many years, they forget about all the other things, is the submission of the annual progress report, which is otherwise known as your employment equity report and your income differential. So the employment equity report and the income differential needs to be submitted every single year by the required deadline. And that this is done online. Currently, the deadline is between the 15th of September and the 15th of January every single year. So this needs to be submitted every single year to the Department of Labour. If you fail to submit, so you don't meet the deadline, what is required to happen is there is no, so you can't apply for an extension. And the consequence of not submitting this report is the Department of Labour can take you to Labour Court and they can issue a fine of 1.5 million. Okay, so it's really important that this report is submitted to Department of Labour. It is a mechanism that they use to try and monitor people without necessarily having to do audits on everybody. Okay, so that is the requirements of the designated employers. That is in essence what is supposed to happen on an annual basis. And as we go through, so just remembering one of the things as well is when we go back here is if you have an employment equity plan, as soon as your plan starts coming to an end, it is really important that you put in place a new employment equity plan. There should be no space within the business that you don't have an employment equity plan. I have a question. I'm just going to stop at that point and ask the question. Nirvana, you want to ask a question? Pose your question and I will come back to you in a minute. Okay. Alrighty, so just going back to here is what I wanted to talk about before we end the session is I've spoken about the harassment and victimization code of good practice. If you don't have that, it's important that you put that in place. It came into effect on the 18th of March, and there's very specific things that you need to put in place, very specific requirements that you need to, as an employer, if you haven't done that, like I said before, you can be held liable for the behavior of the person who has done the harassing. Okay, so the question by Nirvana is it true the Department of Labour can set targets for you? Yes. Okay, so when we look at the amendments that are coming into effect, one of the amendments is the sectoral target. So currently, as I've mentioned before, there is a specific, currently is the way that they look at the targets is you work towards both national and regional demographics. With the changes in the Employment Equity Act is we're going to now have the sectoral targets. So what is going to happen is each business, each particular industry will be given sectoral targets. And so obviously nursing and medical will be very different to manufacturing, which will be very different to retail. And so they're going to be implementing sectoral targets, which they will, I think, is going to say you have X amount of time to reach those particular targets. And if you fail to reach those targets, they also talk about now is that there will be a compliance certificate. And if you don't get a compliance certificate, what will happen is that there will be consequences. So the consequences currently that they're talking about within those changes is that you won't be able to apply for government tenders. I suspect as well is that if you're doing BEE and you're required to submit your employment equity, I suspect that what will probably happen is the BE people will start to ask for your compliance certificate. So they will, with the sectoral targets, what will happen is they will specify a particular time frame. We don't know what the time frames are. They may say 5 years, they may say 2 years, whatever it may be, is they will say you need to reach a specific target within a specific time frame. And if you don't get that, you don't get your compliance certificate. That may then affect your BE rating, but we don't know how it's going to happen. The other thing that's going to happen is they're now they're going to be removing the designated employers by turnover. So the minimum will be that an employer needs to have 50 employees, and they are then required to comply with employment equity. The reason why they're taking the turnover out is because currently, as it stands, is you'll have employers that have 10, maybe 12 employees, but have a turnover that exceeds that. But the change and the requirements of employers now are going to be higher because they're expecting that people need to now transform. The basis on this and why they're putting this in place is they're saying that we've had this particular act, we've been asking people to comply for many years and they haven't. And so now we're going to start to force the change. And so they're going to exclude smaller entities. So anybody less than 50, they're not going to have to comply with the second part of the act, remembering the unfair discrimination applies to everybody, but the having the Employment Equity Committee reaching your sectoral targets, that is going to apply to anybody that is over 50, and then your compliance certificate will come into effect. We're not entirely sure yet how the compliance certificate is going to work. Is there a system much like UIF and or workmen's compensation? How does it work? We don't know that yet. They also talk of having a voluntary submission, but we're not entirely sure yet. So if you do a voluntary submission and you don't comply, so you don't have the meetings, you possibly, not sure, don't reach the targets, will that then affect your compliance certificate? If you submit on a voluntary perspective, do you then get a compliance certificate or do you just submit? We're not entirely sure what happens from that perspective. So as I've mentioned before, the changes are sitting with the president at the moment. We are waiting for him to submit, or at least to sign the amendments, and then that will come into effect. So anybody that has less than 50 employees will now no longer be designated and can apply to be deregistered. Anybody that is more than 50, we're hoping that we will have the sectoral targets then. And at the last roadshow, basically what they said was, even if you have a plan in place, if the plan is ending in 2023, every single employer will need to do a new plan to put in place the new sectoral. So we will need to work towards the new sectoral targets. So we're kind of working in a space that is saying that come this September, every single employer will have a new plan in place anyway, because we will now have the new targets. So we're patiently waiting and hoping that the changes are going to come into effect soon. There is also, when you read the legislation, saying that they possibly may change the date of submission back to the 1st of October. So many years ago, the deadline for submission was the 1st of October. They're looking at possibly changing that again. So any person that is looking at submitting this year, my suggestion is that you start to prepare now for the changes that are coming into effect, so that you're not caught in September. If the changes come then, you're not caught then having not prepared. Okay. That brings us to the end of our presentation. We will be hosting a half-day employment equity session, which is specific to people who are on employment equity meetings, anybody that is required to implement employment equity. So we go into this in greater detail. It is an open workshop. It will be an online session. So it is 4 hours. If you want more information, please feel free to email us and I will send you the booking form and more details. If I remember correctly, I think the date is the 17th of August. As I say, it is an online session. It is half day, and it's specific to anybody that is going to be on an employment equity committee and or anybody that is going to be implementing employment equity within the workplace. So we will be doing that. You can also, if you want to, we have an employment equity checklist. We have a gap analysis, which helps you to understand how you are doing from an employment equity perspective. If you would like the link, please feel free to email us. It will give you a good indication of how compliant you currently are. And we're more than welcome to share that with you. Okay. Yes, the recording is made available. So if you go onto, it's normally uploaded onto our YouTube channel. So if you go to YouTube, you can go to the HR Talk channel. All of our webinars are uploaded on there. And even if you're unable to attend on a Wednesday, you'll be able to go and see it either on our website and or on our YouTube channel. My recommendation is subscribe to the YouTube channel, so when it comes up, you will get a notification. Okay. So that is it for today. I hope that I've made employment equity a little easier to understand. If you do, however, have any questions, please feel free to email us, and I'm happy to assist. Alternatively, is you can give me a call. My number is 083 788 6999. Thank you, and I hope that you've enjoyed the session today.